We begin at the High Court, where another seismic activity has struck the political landscape as judges today declared as unconstitutional 50 appointments made by President William Ruto. In a majority decision, 3 High Court judges today pronounced the contentious position of Chief Administrative Secretary, that is the CAS, as unconstitutional, and subsequently quashed the appointment of swearing in of 50 CASs made by President Ruto. Citizen TV's Ayub Abdikadir was in the Milimani Law Courts, where the landmark judgment was delivered.
It struck like a thunderbolt, and with the stroke of a pen, a majority decision of a 3-judge bench of the High Court quashed President William Ruto's appointment of 50 chief administrative secretaries. The first 4 orders of the majority judges dealt a death blow to the appointments.
The second, to the 51st interested parties, is unconstitutional. D, for the avoidance of doubt, the notification by the first respondent, dated the 16th of March 2023, appointing the second to 51st interested parties to the office of Chief Administrative Secretary, is hereby quashed.
In a landmark ruling, the judges stated that the appointments of the chief administrative secretaries violated constitutional provisions, and the current framework only recognizes cabinet secretaries and principal secretary positions. Justices Kanyi Kimondo, Hedwig Ongudi, and Visram Al-Nashir read the joint majority decision before Justice Ongudi delivered her dissenting opinion.
However, differ with the majority on 2 issues. Namely, 1, whether the office of CAS was constitutionally established, and 2, whether the 50...
The court, among some of the issues it sought to determine, was whether it had the jurisdiction to hear and determine the matter, to which it said,
on the law as set out above, and looking at the various issues raised in the consolidated petition, we are of the view that our mandate has been properly invoked. In particular, the consolidated petition raises numerous and weighty constitutional issues that go beyond employer and employee issues.
The High Court further ruled that while public participation was done for the 23 chief administrative secretaries, the process to appoint the remaining 27 was not participatory.
Was incumbent upon the PSC to prove that the public participation exercise covered all the additional 27 nominees. This was not done in accordance with the BAT case, and in essence, based on the record before us, it is evident that PSC failed in its mandate.
Following the ruling, the Law Society of Kenya, which was among the petitioners, hailed the ruling as historic, cautioning against contravention of the Constitution.
We are delighted that despite several setbacks in court where these decisions have been clarified, finally the High Court has agreed with us and has declared the entire complement of the 50 positions for CAS that were established to be unconstitutional.
The determination by a 3-judge bench of the High Court lays an emphasis on a constitution that's people-centered and people-driven, ready to ring-fence itself from any act of unprocedural addition or omission. A determination that also lays bare a judicial establishment under the current constitutional dispensation that's never afraid of policing the executive against any encroachment. Ayub Abdikadir, Citizen TV, Nairobi.